And we do have a few minutes for questions. I have a question from one of our online viewers, and that is, you're talking about trusts in Delaware, but you're not a Delaware attorney. Do you need Delaware counsel to be able to utilize Delaware law in a document?
Okay. Yeah, the United States is a little different than a lot of countries. We have 50 jurisdictions and 50 different bars that people get admitted to as attorneys, and it's the unauthorized practice of law to practice law in a jurisdiction in which you're not admitted. So anytime we do a trust or any kind of planning for either someone who lives out of the state of New York, or in my case, New York, New Jersey, New York, New Jersey, and Florida, or we do a trust in a jurisdiction that is that in which we're not admitted, we have that document reviewed by local counsel.
So the follow-up to that question is Delaware the only place that you venue trusts? And the answer is no. There are other states. There was just a 60 Minutes report on South Dakota and how billionaires are hiding their money in South Dakota. It was kind of a slanted report, but we use South Dakota at times. We use Nevada at times. They have very good asset protection features to their statute. And the main requirement is you have to have a trustee in that state in order to adopt in to that state's law. But a number of states have now lined up in the competition to be the best trust jurisdiction in the country. Tennessee is in the game, New Hampshire's in the game, but the trust industry in Delaware is a couple hundred years old. It's been around a while. And so you have also the Court of Chancery in Delaware, which is very high-level judges who are former trust and estates attorneys who interpret the law, as opposed to a politically elected Supreme Court judge who is very unversed in trust and estates law. So Delaware has certain advantages over other states. The statutes compete with each other. Depends on the case, depends on the client, and you're free to use literally any jurisdiction law in the country for your clients.
It also depends on the purpose of the trust.
Mm-hmm.
It's really important as well. I have a lot of clients who come to me, that are about to get married, don't want to do prenuptial agreements because they require full disclosure, but they want to make sure that their assets are segregated and protected from a future spouse or the future spouse's family. Mm-hmm. And there are certain jurisdictions that that have better protection for marital assets, including for maintenance and alimony, whereas other jurisdictions don't. So it really depends on what the purpose of the trust is going to be.
Yep. So we'll open it up to other questions.
Hi, along the same lines, Peter, if someone creates a Medicaid trust in New York, but then moves, let's say, to California, would that be recognized, or it has totally different rules? And
depends on California law. California would view that trust. It's not like the general rule that if a will is properly executed in New York and you move to another state, it should be honored and will be honored. Same thing with the power of attorney. Same thing with a healthcare proxy. Not so with Medicaid. Every state, Medicaid is a partnership between the federal government and the states. The states either enact a Medicaid law or they enter into an actual contract with CMS, Center for Medicare and Medicaid Services. Federal law states that the states must comply with certain minimum standards under federal law. So states must pay for nursing home care. They do not have to pay for home care. That's an option. But they can't be more restrictive. They can't change their law like we're seeing now with the new laws in New York. They can't implement them because the federal government has said you can't change the law during the pandemic. But if that person moves to California, it would be a good idea to have the New York Council confer with a colleague in California and see if any amendments need to be made. Now, obviously, that trust may, if it was the trust created by the Medicaid recipient, that trust is irrevocable. So here's the role of a trust protector. Could a trust protector, even though it's irrevocable, make the amendment? New York statute in the State's Powers and Trust Law, EPTL 7-1.9, I believe, says you can amend an irrevocable trust under certain circumstances by court order. But you can't do that if there are, let's say, minors, because now all parties can't consent. So there are lots of ways to deal with it, but the answer to your question is you'd have to look at the local law, and if it wouldn't pass muster there. Now, in California, Illinois, Massachusetts, it might, but if it's Texas or Oklahoma, I would doubt it.
Yeah. In this case, I know California law, actually. I've worked with some clients out there, and a New York trust does pass muster in California. Don't move to New Jersey. New Jersey is one of the most restrictive Medicaid states in the country, and they go after trusts very, very hard. Florida is very much like New York.
So, you might have to decant that. I mean, there are ways to deal with it, but it may not always work depending on the state. Some of the best legal advice I ever gave to a client who lived in Hudson County was to move to Richmond County, Staten Island. And they got Medicaid. They couldn't get Medicaid in New Jersey. So what could I charge for that advice?
And going back to Florida, Florida may accept the trust, but Florida has no home care program at all. The only available Medicaid program is in nursing homes in Florida. So
it's in New York.
yeah, it's New York.
As opposed
Part
to
of the city of New York.
You could go into Richmond County. You could go into. The question is why that particular county, and it really isn't the county, it's the state. It's jumping the state border from New Jersey to New York, gives you the state benefits in New York. And we have a lot of clients that have made that move from New Jersey to New York who wanted to stay at home and get services in their own home.
Or Florida to New York.
Yes.
For exactly the same reason.
Yeah, New York Times actually did an expose on that probably 10 years ago, and they called it the boomerang effect. People who retired to Florida at 65 with all of their retirement income and assets, and at 85 needed to get health care, and they moved back to Manhattan, got an apartment, applied for Medicaid, and got 24/7 care in their own apartment. So that boomerang effect has put New York in a bit of a bind from a budgetary perspective, and that's why they now have that 2.5-year look back for home care that they didn't have before.
So it is going to be much more difficult to access Medicaid community home care benefits when these new laws are implemented. It's not just the new look back period, but there are changes in the way people's needs are assessed. For example, the law will now say that except in limited circumstances, you have to prove you're unable to perform 3 activities of daily living, whereas under the old rules, it was 2 activities of daily living. Now, many people can't perform almost all of the activities of daily living if they've had a stroke or have late-stage dementia, but it is going to be harder, and you can't initially use your own physician to provide the proof. There's going to be so-called independent assessments. But, managed care is being taken to another level of difficulty. Managed care is gatekeeping. It's not providing greater benefits. And what we're seeing is the great state of New York, which has been the pioneer in providing the ability for people to stay at home. We've, in a sense, followed federal court law. The Supreme Court of the United States said, you have a right to be at home and not just be forced to be institutionalized. New York is backing away from that pioneering approach because of a lot of factors, including the high percentage of the state's budget being for Medicaid. We understand that, but our middle-income clients are suffering, and New York is backing away from its wonderful tradition. We need to know that.
We'll take 1 or 2 more questions if anybody has one. All right. Okay, that said, You also have to make sure you inquire of your clients what they own. We mentioned cryptocurrency. I just did a consult with a client, and we went through all of their assets and modest means, and we were going to do a trust. And my son several years ago gave me these coins. They were Bitcoins, and she has 22 of them. And if you know Bitcoin, it's valued at $68,000 per coin. And when they were given to her, they were about $150 to $200 each when her son, and she had no idea what those were worth. So you have to be diligent and make sure your clients come forward with all of that information. Her son does.
And any kind of assets that are internet related, not just Bitcoins. People have domain names that they may have reserved years ago and they completely forgot about. Their Facebook accounts, their email accounts. When somebody dies, it's against the law for somebody to actually go in and close those accounts out, even to access them. So it's really important that that when you speak to a client about what their assets are, you get them to list all of those things as well.
Yep. If your child comes home and says that he bought an NFT and it's a monkey, he did well, because they're worth a fortune at this point. The growth in these assets has just been astronomical. So, all right, I think we're good. Thank you all for attending live. Thank you all for joining us on the web. And remember to turn in your survey sheets. We'll be collecting them at the table out there. And thank you again. We hope to see you next year live and in person for the 17th annual Intergen.